Good morning. My name is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to welcome you to the second match in the 2018 Virtual Supreme Court competition sponsored by the Harlan Institute and the Constitutional Sources Project. Today we have teams from Friscoe, Texas, representing petitioners, Sasha, Chhuprakova, and Nancy Trinh. And we have a team from Creekview High School representing the respondents, Joanna and Makaylia Askew. And this is the case of Carpenter versus United States. Julie, you have anything to add before we get started?
I have just a message of good luck to both teams. We were very impressed by your briefs, and we're looking forward to seeing how you perform in the oral argument round.
Fantastic. So I'm going to turn it over to the petitioners from Friscoe, Texas. You have 15 minutes. You may begin whenever you're ready.
May it please the court. My name is Sasha Chhuprakova, and this is my co-counsel, Nancy Trinh. America was built on the principle of privacy. Our citizens have a right to be protected from warrantless searches and seizures, and the Fourth Amendment ensures that citizens have a reasonable level of privacy, and is backed by various Supreme Court cases that have set precedent regarding citizens' privacy. Carpenter's rights were clearly violated when his phone records were given to the police by his phone company and provided through by the third-party doctrine, where they seized vast quantities of information, including location data, from over the course of 127 days, a time span that is not specific to quantify under the parameters of the Stored Communications Act. Carpenter had a reasonable expectation of privacy because he was not purposefully sharing his location or his cellular data with his phone company. The method by which the authorities obtained Carpenter's data and the tracking of his location for extended periods of time was a form of unconstitutional search and seizure. Additionally, the third-party doctrine should not apply to cellular records, as that would allot an unnecessary amount of power to the government and severely infringe upon the rights of American citizens. The warrantless search and seizure of cell phone data, including location, does violate the Fourth Amendment, as one has a reasonable expectation of privacy whilst using their cellular device, and the actions of the officers were not excused by the Stored Communications Act. The Stored Communications Act allows for court orders under specific and articulable facts showing that there is reasonable grounds to believe that the contents of a wire or electronic communication are relevant to the ongoing investigation. The location data given to and accessed by the police did not fall under the Stored Communications Act, as they did not have enough facts to justify a court order, and they were searching on too broad of a scale. They were not specific as the text of the act suggests, and there was no warrant issued. The information obtained neither falls under probable cause or the Stored Communications Act, making its use to incriminate Carpenter unconstitutional. The Stored Communications Act states that the police must be searching for specific information. However, in the case of Carpenter, they tracked the phone and accessed the data over the course of 127 days, meaning that the contents were without a doubt unusually voluminous in nature, as is prohibited by the said Stored Communications Act. Phone records, including location, taken over the course of 127 days would have been immense, and that is a lot of information for officers to sift through to just find a few pieces of incriminating evidence. And this was not a case where they traced a single phone call or even tracked his location for a single day. This was over the course of 4 months. And though they were not tracking his specific location the entire time, there were spans of multiple hours in which they were specifically tracking his exact location, and that is still not specific enough to quantify.
Counselor, if I could interject for a minute with a question, please. In your brief, you cite the case of United States versus Jones. That was a case involving GPS tracking. How are the facts for this case similar to or different from the facts of the Jones case?
The facts of the U.S. v. Jones are actually pretty similar to Carpenter because they were both tracked using a piece of private property. In Jones' case, it was his car, and in Carpenter's case, it was his cell phone. And they were both tracked, and their location was pinpointed using these cars. But people tried to argue that since they were out in public with these private items, that all of their information was reasonably expected to be public. However, the court found in Jones' case that that's not true, since it was his private car, and tracking this private car by infringing upon that car would be unconstitutional.
But Counselor, isn't there a difference between physically putting a tracking device on the guy's car versus looking at data that's already in existence by virtue of his using a cell phone?
There is a semblance of a difference because, yes, it does not involve trespassing to look at data that already exists, but it is still an infringement of Carpenter's Fourth Amendment rights because he had a reasonable expectation of privacy in those records of his location, because that's not information he was purposefully and willingly sending to his phone company.
Do you see Jones as imposing a requirement of a physical trespass to have a Fourth Amendment violation?
No, I do not. That was just a factor in the case, but it does not mean that it is required to. It is not required for there to be physical trespassing in order for it to be a search and seizure.
Okay, you may proceed.
And the information that was used to incriminate Carpenter was specifically location data. Location data is not telecommunications, so it is not explicitly stated under the Stored Communications Act. And the Stored Communications Act does allow other information sought in other records, but that is not specific enough, and the language should be made clearer so that misunderstandings do not occur. And they did not have enough facts or evidence for a warrant, so the officers tried to use the Stored Communication Act to avoid following protocol and to infringe upon the rights of the common man. Such an infringement of privacy is not only harmful to people like Carpenter, but to every single man, woman, child, and human being that uses a cell phone or other wireless device. The third-party doctrine relies on the assumption that nobody has a reasonable expectation to the privacy of any information that they willingly convey to somebody else. However, there is a gray area when phone companies are involved. Typically, phone companies and network providers are considered conduits or intermediaries rather than actual third parties. They cannot convey the content of any information relayed to them, but rather only data relating to how that information was transmitted. This would include information like phone numbers and maybe the location of a cell phone tower that was used. However, specific location and other data would not and should not be able to be accessed without a warrant. Furthermore, the majority of the American public is unaware of the mass quantities of information that they share with their network providers, and only do so because of the naivety and the necessity of technology in modern day life. A person has no...
Counselor, if I could interject for a second, you made a point a minute ago. Is there a difference between GPS tracking and cell phone tracking? With GPS, it's very precise. You can figure out within a few inches where a person is in the world. But with cell phone data, it's not very precise. And if a person's in a rural area, there might not be any cell phone towers from miles away. So would you draw a distinction between GPS data and cell phone tracking data?
There is a difference between the two, but both would still be an unconstitutional search and seizure because that location data should not be used anyway. Because again, they are not relaying this information to the phone companies on purpose. It's just something that they are forced to do in order to use the phones.
But isn't that part of... Justice Silver, please go ahead.
I was going to ask the same question, I think, which is, people have some understanding of the way that cell phones work, right? And they sign a contract that explains that their data will be shared with this third party. So how does that impact our determination of what is a reasonable, objective expectation of privacy?
People do have a semblance of an understanding of how their cell phones work, but not enough do, and not enough are aware exactly how their location is accessed and how much it is and how much data their network providers and phone companies actually have on them. They're not aware of this. And yes, they do have to sign a contract, but most of those are made in a way where it's written in complex language that the average person cannot understand. It's hundreds of words long, and there's an option where you can skip to the bottom and just click I read it, even though, and most people do not actually read these terms and conditions and do not understand what they're signing up for. And the fact is they do have to sign up for it because it's very difficult to survive in the modern world without a cellular device.
So, Counsel, can you talk for a minute about the Stored Communications Act and how that plays into this case, please?
Yes, the officers used the Stored Communications Act to obtain these records. They got a signed order from a judge, but it was not a warrant to access data over the course of 127 days. But the fact is, the Stored Communications Act says that you have to search for specific evidence, and the data that their officers are searching for cannot be overly voluminous in nature. And searching through data that was 127 days long is overly voluminous in nature, as that has a lot of records.
Is it your argument that the Stored Communications Act is unconstitutional?
No, we believe that the Stored Communications Act is constitutional, but the language that it is written in is too broad and opens the door to more searches that are actually constitutional.
Okay. So, Counselor, if I may, how many days of data was at issue? How many days of Mr. Carpenter's cell phone data did the police get?
127.
Okay, so I take it your position is that 127 is too many, right? Is that
yes?
So, you know, we're a court. We have to draw a line. What would be a good line for us to draw about how much a location data could be given without going through the formal warrant process? What line should we as a court draw?
I would say in non-specific location data, as the ones that were accessed over the course of 127 days, I would say about a week and maybe 2 at most. But for very specific location data, it should be under an hour.
So let me ask the natural follow-up question, which is why draw the lines the way that you're suggesting?
Because if you're searching for location data for over the course of longer than a week or 2, you're not searching for something specific. Within a week, most officers can pinpoint the time a crime occurred within a week, and most communications about that crime would have taken place within that week. So expanding the scope to about 4 months would be unnecessary because most crimes are not planned that much. And again, opening technology more than 2 weeks, that's too much information and too much data that is stored on one cell phone.
But what if the police were looking at not just when the crime was committed, but also the planning phases of the crime? So that could be over the course of a year or even several years that someone is planning a more complex crime. Would we then draw the line differently?
I believe not, because there are other ways to obtain how that crime was planned. Because knowing the location of where people planned this crime wouldn't actually be that necessary to finding out who did it and why. Once they find out who committed the crime, they can take that person in for questioning and find out then. And also they can obtain a warrant if they have enough information to actually be looking into the planning stages, because accessing that vast quantity of information should require a warrant.
Okay, thank you.
You may proceed, Counselor. You have about 3 minutes left.
Okay. The third, Kratz v. the United States established a 2-pronged test to find out whether or not people had a reasonable expectation of privacy. First, it's whether or not they themselves believe that they had a reasonable expectation of privacy. The second prong is whether society was reasonable to expect that they had a reasonable expectation of privacy. And Carpenter did have a reasonable expectation of privacy because he was simply calling somebody from his phone. He didn't think that his location could be or would be accessed. And society also believes that this is a reasonable expectation because, once again, most Americans do not understand that their information is so much of their information is stored on their cellular devices. And as Justin Stewart stated when he was delivering the opinion of the court in Kratz v. the U.S., he said, what a man seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. And Carpenter did seek to keep the contents of his conversation private, as did he his location. When he spoke,
I can interject. How did Carpenter try to keep his? Information private? What steps did he take?
He didn't have to take any steps to seek to keep it private. It's the lack of steps that he took. He didn't broadcast where he was. He wasn't telling people where he was when he was making this call. He was simply making a private call from his private cell phone. To be seeking to keep a conversation private isn't necessarily to have to take steps. It's the lack of taking steps to make it public that makes information private.
Okay, you have about 90 seconds left if you want to wrap up.
Okay. The question that is here today is, does the warrantless search and seizure of cell phone records, including location data, over the course of 127 days violate the Fourth Amendment? And as the petitioner representing Timothy Avery Carter, we say it does. The warrantless search and seizure of Carpenter's cellular data was not protected by the Stored Communications Act. and it was clear that he had a reasonable expectation of privacy regarding his location while he was making a phone call. People should feel secure about the movements they make and the data they store on their phone, as that is their personal property. The government had enough time, but not enough evidence to obtain a warrant, and heavily overstepped their bounds by searching 127 days of cellular data. Furthermore, the third-party doctrine should not apply to cell phone data collection, as that would set a harmful precedent, allowing the warrantless search of vast quantities of data, heavily infringing upon the rights of American citizens. The Supreme Court should rule in favor of the petitioner Timothy Carpenter because it would set a precedent of protecting the citizens' personal information, regardless of where they choose to store it. Ruling in favor of the respondent would mean allowing the government to access almost every single detail of a person's life without a warrant or suitable justification. The era of technology is upon America, and the court should continue to protect the rights guaranteed by the Fourth Amendment, which includes protecting cellular data.
Okay. You have 4 seconds left, so you're right on time. Thank you very much, Counselor. We'll put you on mute. Right there it is. We'll put you on mute, and then we will ask the respondents to come up for a period of 15 minutes. And please take yourselves off mute. And we hear you okay. Counselor, 15 minutes to begin whenever you're ready.
Thank you, Your Honor. May it please the court, my name is Joanna.
And my name is Makaylia, and we represent the respondent, United States.
We are arguing that the FBI did not violate Carpenter's Fourth Amendment rights because, one, the FBI's collection of Carpenter's did not implicate the Fourth Amendment.
2, petition due to the third-party doctrine.
And finally, even if Carpenter had a reasonable expectation of privacy, the Stored Communications Act offers sufficient protections.
First, the FBI's collection of Carpenter's did not implicate the Fourth Amendment. Carpenter's cell site location data is not protected under the Fourth Amendment because he has no reasonable expectation of privacy when moving through a public place. The Fourth Amendment states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, particularly describing a place to be searched.
Sodal versus Cook County defines a search as something that occurs when an expectation of privacy that society is prepared to recognize as reasonable is infringed. However, a person's movements through a public place has never been recognized as a protected element under the Fourth Amendment because a person has no reasonable expectation of privacy in their movements throughout a public place, as held in the United States v. Knotts.
The court in Katz continued this rationale by recognizing that the Fourth Amendment protects persons, not to the petitioner's brief argument. There is no Fourth Amendment protection when the petitioner makes no move to preserve the privacy of the information in question.
The cell site location data that Carpenter is attempting to suppress clearly pertains to a place, not a person, because the only thing the record contains is a location. And Carpenter did not take any steps to preserve the privacy of this location. Had he merely turned his phone off or not accepted any calls while moving through a place he wanted to remain private, the issue would be different. However, he did not, and therefore failed to establish privacy.
Second, even if Carpenter had an expectation of privacy over his location, he has forfeited that protection by giving his cell site location data to a third party. The third-party doctrine was created in Katz v. United States and upheld in Smith v. Maryland, which held that a person has no legitimate expectation of privacy in information he voluntarily turns over to third parties, and that cell phone users do not have any expectation that the data will remain secret when they use telephone equipment.
Counselor, let me ask you a question. Opposing counsel says that they think that most people don't know that they're turning over their cellular data to a third party. So therefore, they do have, for them, a subjective expectation that that information is not going to be shared. And they actually said that most people, because most people don't know that would be objectively, most people would not believe that they are turning over that information to a third party. How do you respond to that?
Well, Your Honor, the Supreme Court has already addressed this issue in multiple counts of case law, such as U.S. v. Graham, and Congress themselves have established this, has declined to recognize this expectation as reasonable by passing the Stored Communications Act itself. And U.S. v. Graham held that even if the defendant did harbor some subjective expectation that his cell site location would remain private, it is not an expectation that society is prepared to recognize as reasonable. U.S. v. Davis established a test to consider when the third-party doctrine does not violate the Fourth Amendment. They held that there is no violation when the records do not contain 1, the contents of any cell, 2, the contents of any call, 3, data from text messages, and 4, cell site location information when the phone was on but not being the received call. And Your Honor, none of these things have occurred.
In the case before the court, the FBI did not obtain the contents of any call, cell phone, or text message. They only obtained Carpenter's location when the phone was making a call.
Your Honor, the court has considered whether to apply the third-party doctrine to cell site location information in cases like United States v. Graham, which held that cell site location information does not implicate the Fourth Amendment, and U.S. v. Powell, which held that there is no reasonable expectation of privacy in cell site location information. Your Honor.
So, Counselor, if I can interject for a minute, you said an important word a moment ago, reasonable, right? Fourth Amendment requires searches to be reasonable. Here you acquire data for nearly 4 months, 127 days. How should this court draw the line of reasonableness? Even if we agree with you that this search could be constitutional, is there some sort of line we should draw of when too much becomes unreasonable?
Your Honor, yes, Your Honor, and Congress themselves have already drawn that line. Congress themselves recognize that contrary to the petitioner's contention, that 127 days collection of cell site location data is not equivalent to 127 days of surveillance, but is instead more like the IRS obtaining of worth of bank records through one search. Using that rationale, Congress themselves drew a line by finding that collecting records of any size, as long as the time period is less than 180 days, that it is constitutional under the Fourth Amendment, as stated in the Stored Communications Act.
Counselor, if I can, does Congress get to decide what is and is not constitutional under the Fourth Amendment, or is that the role of the courts?
No, Your Honor. Congress does not get to decide. However, when Congress drew this line, the Supreme Court found that this line was constitutional in cases like U.S. v. Davis, U.S. v. Graham, and U.S. v. Powell.
And then, Counselor, how do we update those rulings, perhaps after the Jones case from a couple of years ago? In other words, does the line of reasonableness change in light of what happened in Jones?
Your Honor, Jones was a different case because of the physical by putting in a tracker within the car, and the GPS got extended periods of time of real-time location. And the way to adapt to technological changes can be found in Olmstead v. United States, which held that in circumstances of dramatic technological change, the best solution may be found in legislators who are best changing public attitudes, drawing detailed lines, and balancing between safety and privacy in a comprehensive way. Your Honor, United States v. Miller created a way to analyze whether information falls under the third-party doctrine by holding that there is no Fourth Amendment protectable interest in when they are 1, business transactions to which the company was a party, and 2, voluntarily conveyed to the company. In doing so, the court created the requirement that a person have both ownership and possession of the records they are trying to protect under the Fourth Amendment. However, the petitioners have failed to establish that Carpenter had either possession or ownership, and in doing so, forgo the line in the Fourth Amendment, which states that a person is protected in their persons, places, or effects.
So, sorry, Counsel, go ahead, please. I didn't mean to interrupt. Go ahead.
As with the bank records in United States v. Miller, Carpenter can assert neither ownership nor possession of the cell site records. Rather, the cell phone providers created the records for its own business purposes. To address the Miller test, the transaction occurred when Carpenter signed a contract with the telephone company in exchange for their service. And it is clear that the provider is a party in that transaction.
So let's just be. Let me interrupt for a minute. You make a point saying that the cell phone records are not belonging to Mr. Carpenter; they're not his. But aren't they only created by when he moves around? If he sits there and turns his phone off, there are no records created. Why isn't his moving around and using his phone in different places, making a call here, making a call there? Why doesn't that make it his record?
Your Honor, because the records are created, maintained for the company's own purposes. Carpenter has neither contributed to their creation, nor has he actually seen or possessed them.
Counselor, but I'm still struggling, though, because opposing counsel says that, folks don't know that they are sharing this information with their cell provider. They assume that when they place a call, that's private, right? So how do we take that into account when drawing a line for reasonableness?
Smith v. Maryland held that all telephone users realize that they must convey information to the telephone company, since it is through the calls are completed.
But they know that they're conveying some information, but do they know that they're conveying their location? When you place a phone call, do you know that when you place that phone call, a cell provider will be able to determine, within a couple of miles where you're located?
Yes, Your Honor, because in order to place the call must go through a cell tower. And the phone consistently asks, may this phone use your location? And it has up-to-date weather services, all which show a person that the cell phone can be used to track their location, whether or not they choose to be aware of it.
Okay, thank you.
And if I may, Counselor, you're talking about what people know and don't know. That sounds like the CATS test, right? How should the CATS test inform our opinion in Carpenter?
Your Honor, the CATS test should be considered next to the test created in Miller and Davis, and again should be considered that Carpenter has to take steps to preserve the privacy of his record, and he failed to do so.
Mm-hmm. And if I can ask one more follow-up, Maryland was decided, 4 decades ago, and there's been a lot of changes in the Fourth Amendment and in technology in the last 4 decades. Maybe we should revisit Smith v. Maryland. Is this a case that's worthy of a stare decisis?
Well, Your Honor, yes, technology is changing, and the court should remain up to date with this. So therefore, the court can look to U.S. v. Davis, which had almost identical situations and took place in 2014. And U.S. v. Davis held that the third-party doctrine and the Stored Communications Act was constitutional, and that the defendants' actions were voluntary, just as the actions in this one were, because individuals were required to reveal information about themselves to use an important service provided by a business.
Thank you. Okay. You have 3 minutes left. You can proceed as you wish.
Your Honor, even if Carpenter is entitled to certain privacy protections, the extent of those protections offered by the Fourth Amendment has been the topic at issue for the Supreme Court, as previously stated. And again, the best solution can be found in Congress.
Following this reasoning, the court in the United States that Congress has crafted such a legislative solution in the Communications Act, and that the Stored Communications Act conforms to existing Supreme Court Fourth Amendment precedent, and declined to create a new rule by holding that Congress's balancing of privacy and safety is unconstitutional. This act provides that a governmental entity may require the disclosure of a record if the contents of the record were received by a customer of such remote commuting service, as long as the governmental entity obtains a court order by showing specific and articulable facts that are reasonable grounds to believe that the contents of the records are relevant and material to an ongoing criminal investigation.
Your Honor, this act allowed the FBI to obtain Carpenter's cell site location data without an official warrant because it provides certain procedural safeguards to ensure that the protections of the Fourth Amendment are secured. Through the wording of the Fourth Amendment, the Founding Fathers established that to protect a person's privacy, there must be probable cause, a court order, and a way to hold the officer accountable.
The first protection within the Stored Communications Act secures the probable cause protection by setting a statutory standard. The government often issues subpoenas to third parties to provide a wide variety of business records, bank statements, and billing invoices without showing probable cause. By requiring that the FBI show specific and articulable facts that the information is material to an ongoing investigation, the Stored Communications Act offers the defendant more protections than what he would have previously received. This reasoning has been found constitutional in cases like U.S. v. Davis, which held that the Stored Communications Act does not lower the bar from a warrant to a Section D court order. Rather, requiring a court order under Section D raises the bar from an ordinary subpoena to one with additional privacy protections built in.
Therefore, the Stored Communications Act goes above and beyond the constitutional requirements for a compulsory subpoena process, which is what this case would have been without the Stored Communications Act, and therefore addresses the first protection under the Fourth Amendment. The Stored Communications Act also addresses the second, which is a court order, by allowing a governmental entity to obtain digital information only through a court order granted by a magistrate. The final protection offered by the Fourth Amendment is addressed because the Stored Communications Act holds the governmental entity accountable by requiring a detached and neutral magistrate, as held in United States v. Caro, and because it bars the improper disclosure of digital information.
You can finish your sentence, Counselor.
Of improper disclosure. Therefore, we pray that this court rule in favor of the respondents.
Thank you very much, Counselor, for respondents. I'm going to put you on mute, and we will ask the Counselor for Petitioners to return, and you have 5 minutes for rebuttal time, and you may begin whenever you're ready.
The warrantless search and seizure of cell phone data, including location, does in fact violate the Fourth Amendment, as one has a reasonable expectation of privacy when using their cellular devices, and the actions of the officers were not excused under the Stored Communications Act or the third-party doctrine. As citizens in America, you understand that when you place a call, you are putting out some information as to where your location may be. However, you have a reasonable expectation of privacy as to that location not being broadcast and not being given out to other people. That was the case of Carpenter, where he believed that his location was private. He believed he had a reasonable expectation of privacy as he was not broadcasting his information out to the people around, to others, and along with that, he was not voluntarily handing his information over to be given to police.
So, Counselor, can I ask a question? Your friends on the other side said that if there's a problem with the Stored Communications Act, rather than this court finding a constitutional violation, it would be better for Congress to revisit the statute and perhaps update it. It's a very old law, and they can update it in light of new technologies. Why should it be the role of this court to fix statutes that are within Congress's power to fix?
Well, I believe that the Supreme Court has the responsibility to be able to guide the way as to showing how our amendments should be protected, enforcing that our rights be protected throughout our government. And I believe that the court has this power to show how Congress must revise laws, must revise provisions that no longer fit our day and age to better protect the rights that were given to the citizens of America. And on top of that, it takes congressional legislation often takes a very long time with how fast technology is moving and with how much technology encompasses our society. I believe that it is very important to have a ruling now to kickstart maybe further legislation to further protect the privacy and rights of Americans.
Is it your position that the courts are in a better place to update laws than is Congress?
I believe that it is that the courts can help Congress push legislation through, because the government does all work together branch by branch. And I believe that the courts have a duty to protect the rights of the citizens. And by pushing an agenda such as this, Congress can therefore take action as well.
Okay, Councilor, you can proceed.
Okay. In U.S. v. Jones, a GPS tracker was placed on Jones's car, and his location was tracked throughout. And in that case, the court decided that that was a violation of the Fourth Amendment, citing that just because one is in public doesn't mean their information is up for grabs. This also was the case for Carpenter. He made a private call. He did not broadcast this call. He did not mean for this call to be accessed by other people, yet his information was given up through a provision of the third-party doctrine. And we believe that the third-party doctrine should not apply to telecommunications data, as with how heavily our society relies on technology, that how heavily society relies on technology, we believe that the third-party doctrine opens the door to too much information being accessed by the police or other entities. As opposing counsel has said, the court should remain up to date. Sorry?
As
opposing counsel has said, they believe that the court should remain up to date on technology. And with that, we believe, the petitioner believes that the third-party doctrine is therefore too broad, and we believe that U.S. v. Graham, where the court had stated, which was not a Supreme Court case, stated that location data not being, like on-site location data not applying, we believe that that should not apply, because, sorry, I misspoke. We believe that the third-party doctrine should not apply to telecommunications data. We believe that the Stored Communications Act should not apply here. We believe that...
okay, you can finish your sentence, Counselor.
Okay, we believe that citizens have a right to their privacy, especially on their phones, considering how much of our society is based on communications and data stored on our phones.
Okay, very good. Thank you, Counselor, for the petitioners. We'll put you on mute. And we'll go back to counsel for the respondents. You have 5 minutes of rebuttal time. You may begin whenever you're ready. Hold on. You just muted. Okay, so you can unmute your phone. We're ready to roll.
Is it unmuted?
Yes, you are. We can hear you. You can begin whenever you're ready, Counselor.
To address some points made by the opposing counsel, Your Honor, there is no case law accepted by a Supreme Court case that states that a person must broadcast their information in order to give up their right to privacy. There is, however, a case law that states that a person must take steps to preserve their privacy, which is United States v. Katz and United States v. Smith, and Smith v. Maryland. And Carpenter has not taken any steps. Smith v. Maryland has found that information might be public even without a person's direct knowledge of it being public because of their actions. In this case, and in that case, signing a contract and giving up information in exchange for business services. Furthermore, Your Honor, contrary to the petitioner's argument that collecting cell site location for 127 days is too broad to be constitutional, the collection of 127 days does not push the FBI's collection past the safeguards of the Stored Communications Act, nor does it violate the Fourth Amendment, because U.S. v. Graham held that the acquisition of cell site location data pursuant to the Stored Communications Act does not implicate the Fourth Amendment regardless of the time period involved. And U.S. v. Davis...
Now, Counselor, if I may, the Graham case and Davis, were those Supreme Court decisions?
No, Your Honor. However, they are the most recent cases, and because a pressing issue is the government being able to adapt to technology, we should give weight to the most recent cases who dealt with the most recent technological advances.
Did all the lower courts reach the same conclusion on this question, or is there a division or a split of authorities?
Your Honor, in U.S. v. Graham, there might have been a split of authorities. However, this holding is the majority.
Okay.
Counselor, can I also ask a question, which is opposing counsel says that the SCA should not apply in this case. How do you respond to that argument?
Well, Your Honor, the Stored Communications Act was specifically made to counteract advances in technology by Congress and then upheld by the Supreme Court. And it was created to allow governmental entities to obtain digital information, which includes cell site information, safeguards. Without the Stored Communications Act, it's not that the digital information would have been collected through the Fourth Amendment. Instead, the digital information would have been collected through a subpoena process, which offers almost no protections. So by passing the Stored Communications Act, Congress has granted the defendant more protection than he would have previously received.
So then you disagree with opposing counsel who thinks that Congress ought to pass a new, more updated piece of legislation that would apply to the modern usage of cellular technology. This was obviously a statute that was passed in the 1990s.
Your Honor, to require and to pass a ruling requiring that Congress create new legislation every time there's a technological advancement would place an undue burden on Congress and prevent them from actually being able to create legislation, because technology is advancing every year and we're advancing and finding new situations every day.
But we're not asking Congress to pass a new piece of legislation every time a new iPhone comes out or a new Samsung Galaxy comes out, right? This is a statute that was passed in the 1990s. It's 2018. Technology has advanced considerably in that period of time. Why not just update it to reflect the technology that exists today? So we do it every 20, 30 years. That would be burdensome for Congress to do?
Your Honor, the best solution can be found in Olmstead v. United States, which, as previously stated, can be found in a legislator. And while it is open for Congress to edit or to create an all-new legislation, U.S. v. Davis has found that this legislation applies to modern technology and has found that the Stored Communications Act adequately addresses any privacy concerns that can be found in today's modern society.
Okay.
Counselor, you have 30 seconds left. I'll ask a simple question. Why can't the police just get a warrant here?
Your Honor, it's not that the police would have to get a warrant. It's, again, without the Stored Communications Act, they would be the only thing they would be required to do is to get a subpoena process, which does not offer any protections. Had the police chosen to get a warrant, then that could have taken more time and allowed more monitoring.
You can finish your sentence, Counselor.
And even if a warrant would be required, the police got a court order under the Stored Communications Act in good faith, which is an exception to the Fourth Amendment.
Okay, and that's enough. Your time's up. Thank you so much, Counselor. I'm going to put you on mute temporarily. Let me begin. Both of you did an absolutely wonderful job. These are very difficult questions which professional lawyers argue over and grapple with. And you managed to handle these questions with grace, with elegance, with intelligence, with sophistication. We tossed some really hard questions at you, one after the other, and you nailed them. So we're very proud of you. This is the second match of 6 matches for the Supreme Court competition. The final round will be held on April 26th at the Georgetown Supreme Court Institute. 2 teams will advance, 1 petitioner and 1 respondent. And we're all very proud of you. Julie, is there anything else you'd like to add?
Yeah, I just want to reiterate that you both did a wonderful job. Congratulations on making it this far and performing very well in the semifinal round. One logistical note is that the semifinal round is actually kind of split between like a 2.5 week period. So you will probably not hear back from us until I think the 29th of March. So we just want to make sure that there is going to be this lag time, and it's because we had to split up their rounds to accommodate scheduling. So you will hear from us by the end of this month about whether or not you will be advancing to the final round in Washington, D.C.
Thank you so much. And with that, the case is submitted for consideration. The court is adjourned. Thank you.